Today we're going to cover the defenses to negligence. After completing this chapter, you should be able to identify the elements of contributory negligence, comparative negligence, and assumption of risk. You should be able to recognize the exceptions to the contributory negligence rule, namely the last clear chance doctrine. Recognize the problems that arise in the administration of a comparative negligence system. Differentiate between contributory negligence and assumption of risk. Identify situations in which immunity can be raised as a defense. And finally, recognize the purpose behind the problems inherent in a statute of limitations defense. Exhibit 8.1 provides a list or a chart of the various defenses to negligence. So in a contributory negligence defense, plaintiff is barred from recovery. So contributory negligence is also known as an all or nothing defense, where if a plaintiff is proven to be contributorily negligent to their and in the cause of their harm, they will be barred from recovery. Comparative negligence, on the other hand, reduces the plaintiff's recovery based on how negligent they were in causing their harm. So it really looks at the plaintiff's behavior and reduces their damages award based on how negligent they were, in addition to the defendant's negligence. The assumption of risk defense allows a plaintiff to either have their recovery reduced or barred completely, depending on what state you're looking at. Immunity is a defense that can be raised based on special status or relationships, in which case a plaintiff will be barred from recovery and will not be able to recover from someone who has immunity. Finally, statutes of limitation and statutes of repose will also bar a plaintiff from recovery if they try to bring a cause of action or sue outside of the statutes of limitation and when that has expired. Contributory negligence, in essence, really shifts the loss from the defendant to the plaintiff by completely barring the negligent plaintiff from recovery. The plaintiff is barred even though the defendant was negligent, and in most cases was more negligent than the defendant. So it really is an all or nothing type of defense, and is pretty harsh in terms of punishing the plaintiff for their negligent behavior. It's a judge-created rule built on the rationales that negligent plaintiffs should be punished for failing to protect their own safety and not being careful enough, where that plaintiff's negligence becomes a proximate cause of their own injuries. Another practical rationale explaining the judicial creation of contributory negligence is in judges' historical distrust of juries and their fear that juries are just going to go wild and award crazy damage amounts, which they have in some cases to injured plaintiffs, where each trial basically becomes who can get the jury to sympathize or empathize with the plaintiff the most, thus awarding them huge amounts of damages. So it's really the judge's distrust of juries. Now, while it is mainly an all or nothing defense, there are, of course, exceptions to the contributory negligence rule, mainly which is the last clear chance doctrine. So before I get into what the last clear doctrine, the variations of where the last clear chance doctrine applies, I want to talk about when it is not applicable. So under the last clear chance doctrine, if the defendant has an opportunity that is unavailable to the plaintiff to prevent the harm that occurs and doesn't take advantage of it, the defendant will remain liable despite the plaintiff's contributory negligence. So basically, if a defendant fails to take advantage of an opportunity to prevent the harm, this will basically wipe out or negate any of the plaintiff's contributory negligence. So this is a way that courts have, or jurisdictions have, tried to mitigate the harm and the punishment that contributory negligence has on the plaintiff. Now, before I get into the variations of when this doctrine applies, I just want to get into when it doesn't apply. So if both the defendant and the plaintiff are inattentive so that neither discovers the danger, then the last clear chance doctrine will not apply. Also, if the defendant discovers the plaintiff's peril but can't avoid it because of the defendant's earlier negligence, most courts won't allow the last clear chance doctrine to be applied either. Generally, the last clear chance doctrine won't apply when the defendant's original act of negligence precludes him or her from avoiding the accident after she discovers the plaintiff's peril. So, for example, if a defendant is driving with defective brakes, therefore making them engaging in negligent behavior, and they see a plaintiff who's stuck in the middle of the road for whatever reason, the plaintiff will not be able to assert the last clear chance doctrine because the defendant doesn't have an opportunity to avoid that harm since their brakes are defective. So that's the general rule in which the last clear chance doctrine will not apply. With that, let's go ahead and discuss the variations in which you might see the last clear chance doctrine. So if the plaintiff is helpless and the defendant discovers a danger but negligently fails to avoid it for whatever reason, the plaintiff can recover in all courts. Now, if a plaintiff is helpless and the defendant fails to discover the danger because he's inattentive, the plaintiff will still be able to recover in most courts. So really sympathetic to a helpless plaintiff where a defendant either negligently fails to avoid the harm or is inattentive and can avoid the harm or discover the danger, the plaintiff will be able to recover. Now, what if the plaintiff is not attentive, what if the plaintiff is attentive but not helpless, and the defendant discovers the danger but negligently fails to avoid it? The plaintiff will still be able to recover in most courts. So in that situation, let's suppose that a plaintiff negligently turns her vehicle in front of the defendant, and the defendant, who could have avoided the accident had he been paying attention, was too busy texting and is unable to avoid the plaintiff by the time he sees her. Most, but not all courts, will apply the last clear chance doctrine and allow the plaintiff to recover. Now, what if the plaintiff is inattentive but not helpless and the defendant fails to discover the danger because he is inattentive? So remember, I discussed that if both plaintiff and defendant are inattentive, then the plaintiff cannot recover and the last clear chance doctrine will not apply. Okay, finally, what if the defendant is unable to avoid harming the plaintiff, even though he's aware of the danger? Because of the defendant's earlier negligence, the plaintiff cannot recover in most courts. So again, that's the example I provided where the defendant had the defective brakes. They're unable to avoid the harm, even though they're aware of the danger that the plaintiff is in the middle of the road because of the defendant's earlier negligence of driving with those defective brakes. Again, in that situation, the plaintiff can't recover in most courts. So Exhibit 8.3 provides a breakdown of these various exceptions that we just discussed to the contributory negligence rule. So if the plaintiff's negligence doesn't meet the standards of a but-for or substantial factor tests, meaning they aren't actually, their negligence doesn't have any effect whatsoever on the harm caused by the defendant, then the contributory negligence defense will not apply. So if a defendant, hits a pedestrian walking down the street, and in addition, while the plaintiff is walking down the street, they're injured by an explosion that happened from a window of a storefront. That negligence, because they weren't paying attention, that negligence will not meet the standard of the but-for or substantial factor test. It's an unforeseen harm caused by the negligence of the plaintiff that will which will rise to an exception to the contributory negligence rule. Another exception is where the harm likely to occur as a result of the plaintiff's negligence occurs in an unforeseen manner. Next is the last clear chance doctrine, which we just spent quite a few minutes talking about, where the defendant did not take advantage of an opportunity to avoid the accident and the plaintiff had no such opportunity. So again, it won't be applicable if both the plaintiff and the defendant were inattentive, or if the defendant's original act of negligence made it impossible for him to avoid the accident, so the defective brakes. Another exception is if the defendant committed inattentional tort, so you cannot raise the contributory negligence rule in any intentional tort, such as battery, intentional infliction of emotional distress, Another exception is if the defendant was willful and wanton or reckless in their behavior. They will not be able to assert that the plaintiff was contributorily negligent in that situation. And also if the defendant was negligent per se. Only if the statute's intent was to place sole responsibility on the defendant and was enacted to protect the class of people to which the plaintiff belongs. So for the final exception, you have to really look at what the statute's intent and whether or not the plaintiff belongs to the class of people through which that statute is intending to protect. Next, we're going to move on to comparative negligence. It's the alternative to the all or nothing approach of the contributory negligence system. You have an excerpt in your book from the Lee versus Yellow Cab Company case. I provided the full case, which was decided in California as part of the modules, because this is basically the transition that California had made from contributive negligence to becoming a pure comparative negligence state. Under the comparative negligence doctrine, the plaintiff's recovery is reduced in direct proportion to his or her degree of negligent contribution to her own injuries. So if a plaintiff is found to be responsible for, let's say, 20% of her injuries and suffers damages of $1 million, her recovery would be reduced by 20% of the $1 million to $200,000. Today, most states have adopted a comparative negligence system by statute or through a state court decision, such as California and the Lee versus Yellow Cab Company case. Now, there are two types of comparative negligence, pure and the 50% approach. Under the pure system, the plaintiff can recover no matter how extensive his or her negligence. So if the plaintiff is found to be 80% negligent by the jury under a pure comparative negligence system, he will still be able to recover 20% of his damages, even though he was 80% negligent. Now, this is contrasted with the 50% approach, where a plaintiff would be precluded and barred from recovering because he's more than 50% responsible for his or her own injuries. So under the 50% approach, there's a further breakdown of the not as great as and the not greater than. So if they're under the not as great as, this is the 49% and under. If they're 49% or less contributorily negligent to his or her injuries, then they're not going to be able to recover. Then they will be able to recover. But if they're at 50% or higher, then they will not be able to recover. So that's under the not as great as. Now, under the not greater than, if they are 50 and 50, then they will still be able to recover. Now, if you can imagine that this is a very fine line to decide, because this comes down to really the jury to decide what's going to be the final straw in determining whether it's not great as, not greater than, and how do you decide that percentage of negligence on the plaintiff's part. So again, many problems can be related to comparative negligence. Mainly, how is fault assigned, especially when there is multiple defendants? Under a pure comparative negligence system, such as California, the answer would be simple. The negligence of all parties would be considered, and the plaintiff would be allowed to recover in direct proportion to the negligence of all of those parties combined. Now, that's a little bit more difficult to answer under the 50% approach. Additionally, does the last clear chance doctrine still apply? And should a negligent plaintiff's recovery be reduced if the defendant was negligent per se under a statute? So these are some of the problems that are related to the comparative negligence defense. Now, under the defense of assumption of risk, a plaintiff who volunteers to take the chance that the harm will occur is said to have assumed the risk. The basic elements of assumption of risk require that the plaintiff must have actual or constructive knowledge of the risk, the plaintiff must appreciate the character of the risk, and the plaintiff must voluntarily accept the risk based on the time, knowledge, and experience to make an intelligent choice. Under the assumption of risk defense, the defendant has to prove that the plaintiff had actual or constructive knowledge of the actual risk prior to engaging in the injury-causing conduct. If there's a limitation on liability buried in the fine print, for example, of a waiver, let's say, where the plaintiff is unlikely to see it, then a defendant will not be able to raise the assumption of risk defense. A defendant's failure to establish any of these three elements of this defense will not be able to prevail on the defense of assumption of risk. Now, how does the assumption of risk compare or relate to the contributory negligence defense? Some states have basically abolished the doctrine and consider assumption of risk to be a form of contributory negligence. The justification behind merging the two is often that a plaintiff who's assumed the risk has also been contributory negligent. So by assuming this risky behavior and accepting any potential harm, they're basically being contributory negligent to incurring that harm. So a plaintiff who voluntarily but unreasonably decides to take a risk can also be said to have behaved in a negligent manner by voluntarily assuming that risk. Now, a plaintiff is not automatically negligent simply because he has assumed the risk. What do we mean by that? Let's look at the differences between the assumption of risk and contributory negligence. So under the contributory negligence, this is characterized as acting in a reckless behavior or recklessness. On the other hand, assumption of risk could be characterized as adventurousness. So when we think of assumption of risk, we're thinking about people who sign waivers to go skiing at a resort or to go skydiving. There's extensive waivers that you have to sign where you agree to assume the risk that this type of activity, which is usually an adventurous, outdoorsy, exciting type of activity could lead to harm or even potential death. So while contributory negligence is basically considered reckless behavior, assumption of risk applies more to adventures or behavior that is adventurous. Contributory negligence is based off an objective standard. So the plaintiff's behavior is going to be compared to that of our good friend, the reasonable person, the reasonably prudent person. So it's an objective standard, whereas an assumption of risk will be decided on a subjective standard. So did the plaintiff understand that risk based on the facts and the circumstances and the situation? Under contributory negligence, it's not a defense to reckless conduct, whereas on the other hand, assumption of risk is a defense to reckless conduct. Finally, contributory negligence is not generally a defense in strict liability cases, simply because they want to hold industries, manufacturers strictly liable for any defective products that they release into the mainstream. Assumption of risk, however, is a defense in strict liability cases. So now we're going to move on to immunities. Immunity is a complete defense to tort liability in that it completely absolves the defendant of all liability. It's granted to those entities that bear a particular relationship to the plaintiff, such as a spouse, or who occupies a status, such as that of a government or charitable entity. So under the FTCA, or the Federal Tort Claims Act, money damages can be recovered against the United States for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of his or her employment under circumstances where the United States, if a private person, would be liable to the claimant. There are exceptions to the scope of the FTCA, so the U.S. wouldn't be liable for intentional torts such as assault, battery, false imprisonment, false arrest, abusive process, malicious prosecution, except when they are committed by federal law enforcement officials. So if intentional torts are committed by federal law enforcement officials, the U.S. will and can be liable. Another concerning exception to the FTCA pertains to a federal agencies or federal employees exercise or failure to exercise a discretionary function or duty. So, what is or what constitutes a discretionary function? Um, is basically when there's room for policy judgment and decision. So if a federal agency or a federal employee even abuses their discretionary function, the U.S. will not be held liable in that situation. The reason being that they wanted these federal agencies or federal employees to be able to exercise judgment and to do their job when dealing with discretionary function without the fear of being sued. So that's somewhat alarming, but that is an important exclusion to the FTCA that you should be aware of. And in terms of state government, judges and legislators are almost never liable for their acts for the similar reasons to encourage them to act competently in their jobs and to not be afraid to make decisions, tough decisions um, that are within their scope of duty in fear of being sued. So they have immunity for that reason. Um, so sovereign immunity has almost all been but abolished from state government, but it's been replaced with the statutory form of immunity, again, which protects judges and legislators. Local government entities like police and fire departments, K through 12 school systems, public hospitals or county hospitals have basically enjoyed at least partial immunity. Whether or not they are immune depends on the context of their function. So if it's a governmental function, then they are subject to immunity, whereas proprietary functions would not be subject to immunity. What counts as a proprietary function? It's one that could be performed by a private corporation or by the government. So, such as gas and electric or utility companies, city airports. Now, on the other hand, police and fire departments and school systems are typically exclusively involved in governmental functions and for this reason would enjoy partial immunity for that or would enjoy immunity for being specifically a government for engaging in specifically governmental activities only as opposed to proprietary functions. So under common law, the wife was said to have been, her identity has said to have been subsumed into that of the husband, and therefore they were protected from interspousal immunity, where the wife technically had no legal rights to sue her husband because she would basically be, the husband would in effect be suing himself, since the wife and husband were said to have been one identity. Most states have since abolished the interspousal immunity, California included. Under the parent-child immunity, it was the same theory as the interspousal. Proponents of parent-child immunity said that we're fearful that allowing a parent to sue their child or a child to sue their parent would encourage disharmony, collusion, and fraud, and disrupt the family unit. But parent-child immunity has been abolished pretty much in all states. And finally, charitable immunity received immunity under the common law in some states. The purpose of the charitable immunity was to protect charitable institutions from tort claims and thereby promoting their existence. So, in order for them to function normally as a charity without having to fear being sued, charitable immunity was implemented in some states. In California as well, charitable immunity does not exist, but it's important to be aware of these immunities and their purpose. Finally, we're going to cover discuss the defenses of statutes of limitation and statutes of repose. A statute of limitations, as the name indicates, is a statute limiting the time in which an action can be brought. Any action not commenced within that time period is barred. The purpose of the statute is to protect individuals from having to defend super old claims. It also allows people to have some measure of stability and predictability and foresight in their lives by limiting the time frame in which they can anticipate being sued. Under the statute of limitations, this typically begins to run at the time of injury. Now, what about when what about in a medical situation where symptoms or indication of any harm isn't apparent within the statutes of limitations? Let's say some negligent behavior during a surgery doesn't present itself until 10 years later, and this is outside the scope of the statutes of limitations. Some courts have created the so-called discovery doctrine in response to this type of situation, which provides that the statute does not begin to run until the injury is or should have been discovered. So typically the statute of limitation begins to run at the time of injury, where in courts where they do apply the discovery doctrine, in that situation, the statute won't begin to run until the injury is or should be discovered. So while the statute of limitations begin to run at the time of injury, a statute of repose begins to run at the date of sale of a product. These statutes are designed to limit a manufacturer's liability, to lower insurance costs for manufacturers so they don't have to pay for insurance indefinitely for 50 years, anticipating potential lawsuits that far in advance, and to introduce a sense of certainty in the area of product liability litigation. And that concludes our discussion on defenses. Thanks for listening.